Good morning.
Okay.
All right, we are on the record in the matter of People versus Johnathon Lewis Walton, and I have two case numbers. I have 19-0043-SM, and I have 19-0847-FY. And may I have appearances for the record, please?
Your Honor, Melissa Vachon on behalf of Mr. Walton for purposes of arraignment while he appears separately by video.
Thank you. And Mr. Walton, sir, could you state your name for the record, please?
Johnathon Walton.
Thank you, sir. So we are here today for an arraignment, and let's just double check here. So you've been arraigned on the actual charges in the misdemeanor larceny case from 2019. I don't believe you've been arraigned on the felony accusation of stealing a financial transaction device. So let's start with the misdemeanor case. And we're going to go back in time a little bit. I don't know. Actually, I'm going to start with an arraignment on the felony case because all of the information there may be a reminder for the misdemeanor. Okay. I'll start with an arraignment. So, Mr. Walton, I call arraignments the worst case scenario hearing, and here's why. I'm going to read the charges against you, and you're not going to be allowed to say anything. There's a reason for this. You are innocent in the eyes of the law. I'm not going to let you. Attorney Vachon is certainly not going to let you say anything that could come back to haunt you later. Okay? You have a right to know what you're accused of. Okay? You have constitutional right to know what you're accused of. You can't really defend yourself unless you know what you're accused of. So that's why we have this hearing. It looks like this hearing was not done in the felony case back in 2019, so I'm going to start with that one. Then, just to be sure we're all on the same page, I'm also going to read the charges in the misdemeanor case, even though that was done some time ago. Okay? All right. So we're going to do 5 things this morning. I'm going to read the charges against you with the maximum possible penalties. We're going to talk more about your rights. Attorney Vachon is going to ask the court to enter a not guilty plea on your behalf, and the court's going to do that. Then we're going to talk about some dates when you return to court. Okay. And lastly, we're going to talk, Attorney Vachon is going to speak about bond or bail, and the court will decide. Okay. So first, the most important thing I can tell you this morning is that you are innocent. You are innocent in the eyes of the law, and you remain innocent. Unless, not until, unless you plead guilty or found guilty beyond a reasonable doubt at a trial. And I say unless because it's different than until. Until means something's going to happen sooner or later. If I say we'll be here until Thursday, we know Thursday is going to happen. If I say we'll be here unless Thursday happens, then we have a whole different conversation, right? We don't know what's going to happen in this case. You haven't seen the evidence. Attorney Vachon hasn't seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or found guilty beyond a reasonable doubt. Now, that said, I'm going to read the charges against you. So, in case 19-0487-FY, the felony case, you are accused of having stolen or retaining without consent a financial transaction device, in other words, a credit card or debit card. In count 1, the specific allegation is that you did knowingly retain, knowingly possess, knowingly secrete, or knowingly use a financial transaction device without the consent of Maxwell Christians, the device holder. And this is alleged contrary to Michigan law, MCL 750.157N1. This is a felony, punishable by up to 4 years in prison and or $5,000 in fines. The court shall order law enforcement to take a DNA identification profiling sample before sentencing or disposition if it was not taken at arrest. And this is alleged against the peace and dignity of the people of the state of Michigan. Excuse me. So in case 19-0043-SM, you are accused of larceny, of something having value of 200 or more, but less than 1,000. And the specific allegation is that you did commit the offense of larceny by stealing a PlayStation 4 that belonged to Anthony Bowen. The value of property stolen was $200 or more, but less than 1,000. And this is contrary to Michigan law, MCL 750.3564A. This is a misdemeanor carrying up to 1 year in jail and or $2,000 in fines, or 3 times the value of the amount of property stolen, whichever is greater. To impose a fine of 3 times the value, the defendant must admit to the amount, or it must be, or it must be determined by the trier of fact at trial. And this is alleged against the peace and dignity of the people of the state of Michigan. Now, Mr. Walton, you have certain rights. Have you had an opportunity to discuss those rights with Attorney Vachon?
No.
Okay, well, you have a right as this case goes forward to have these charges heard at a trial. And at that trial, the prosecutor would have to bring the evidence against you. And you could question that evidence. You could bring evidence, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. Most importantly, at that trial, you could testify on your own behalf, or you could remain silent. And no one could use that silence against you. They couldn't say, well, Mr. Walton didn't have much to say there, did he? No, not allowed. You have a right to remain silent if you choose. You will have other rights, or the rights will apply to other hearings as we go forward. Always ask your attorney, okay? And Attorney Vachon, does Mr. Walton plan to apply to your office for services?
Yes, Your Honor, for both files.
Okay, thank you. So, Mr. Walton, as I said, you have a right to an attorney. If you can't afford an attorney, the court will provide one for you. And I am particularly proud of the superb public defenders we have in this court. Now, if you win the Powerball or something, and you are suddenly financially not eligible for the public defender, you would retain an attorney, you would choose that attorney, but you would have to pay them out of pocket. Attorney Vachon, how does Mr. Walton wish to plead?
For a not guilty plea for both files, Your Honor.
All right, and the court will enter that plea, or those pleas. So, Mr. Walton, a matter of housekeeping, and please don't go too, actually, I'll just ask Attorney Vachon, is the Stout address still accurate?
No, Your Honor, I will put the new address in the chat.
Great, thank you. Okay, so Mr. Walton, you are going to receive these dates in the mail. Okay. You will return to court in the misdemeanor case, the larceny PlayStation case, at 1 p.m. on January 31st for what we call a pretrial conference.
Your
At
Honor,
2 p.m.
Your Honor, this is the felony case. I think I didn't realize. Let me give you the dates for those. That's going to be for the felony, that's going to be January 26th at 8:30. And then for the prelim date, that's going to be February 1st at 9 a.m.
Thank you very much. And again, Mr. Walton, you will receive those in the mail. Okay. Attorney Vachon, would you like to be heard on bond or bail?
Yes, Your Honor, I would. I would request the personal recognizance bond for Mr. Walton in both files. He is currently living in Iowa. He is working full time. He has a child as well that he's raising. He has connections there in Iowa. He lives with his girlfriend, and his girlfriend's family is in Iowa, which is why they're in Iowa right now. He also appeared today as ordered. I know he missed an arraignment date earlier for this case this week. He explained that he works overnights and his phone alarm didn't go off that morning. He did call the court to get new dates scheduled. So I would request a PR bond. He is committed to resolving these matters.
Okay, thank you. So, Mr. Walton, the court is going to grant your attorney's request for a PR bond, and that means we take you at your word that you will continue to appear. If for some reason you don't appear, then the court will issue a bench warrant, and the bench warrant will be for $5,000. So you'll have to post that in order to get out. I'm going to put some other conditions on this bond. Feel bad about this, but you may not commit any crime while released. Okay. You must immediately notify this court in writing of any change of address or telephone number. You may not use alcohol, marijuana, or any illegal controlled substance. If you have any medications, you are to take all medication as prescribed. Do you have a medical marijuana card, sir?
No, ma'am.
Okay, so you may not use marijuana at all, and you may not apply for a medical marijuana card while this case is pending. You may not possess or purchase a firearm or other dangerous weapon. You may not engage in any assaultive, threatening, harassing, or intimidating behavior toward anyone. You specifically may not have any contact with Maxwell Christians or Angela Christians, or, excuse me, or Anthony Bowen. You may not have any third party contact them, and you may not use any social media to get any messages to them. I believe that's all. Attorney Vachon?
I have nothing else, Your Honor.
Okay, thank you. All right, Mr. Walton, your case is going to come back before me. I wish you the best of luck. I will also tell you the most important thing you can do for yourself while this case is pending is ask your attorney anytime you have a question. If you don't understand something, or if you kind of sort of mostly do, ask your attorney, and that helps your attorney represent you as well. Okay? Okay. Thank you. That is all for this record.
Thank you.